Keeping in mind the fact that compliance isn't just about your systems and computers, that a lot of the data breaches happen down to forgetfulness, and I don't know if anybody wants to share an example.
Yeah, I had a very bad experience 1 week ago. So I was walking my dog, went outside, we live in Frankfurt, walking outside my front door, was walking the dog, and by sudden I saw a data stick, and it was an advertised data stick with ECB. I said, okay, someone lost this data stick by purpose. So I grabbed it from the ground, put it in my pocket, and said, okay, because ECB is one of my clients, so I have a huge data protection, data security assignment with them. So I said, better I take it than anyone else. But probably, I thought, probably just some personal vacation photos or whatever on it. I mean, it's just a data stick. So I went at home, put it in the computer or in a spare laptop, not of course in my computer system. Said, unfortunately not. I mean, ECB, huge, major spreadsheets with calculations on it for future whatever policies. I don't want to state that here. No password at all. The author striked, the title of it, strictly confidential, internal use, ECB only, and so on. So I called my contact in the HR department, said, he was like, I'm getting a heart attack, please, 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 don't put it in an envelope and send it by post because it's strictly confidential. Please, would you please bring it in person to our office? So I did. I was immediately surrounded by 3 security guys from the ECB and said, yeah, I just want to hand over the stick. Oh yes, so everything was fine. I mean, that happens.
Right.
Just be aware, you might, and your employees, your freelancers, whoever's using data, and they're doing it probably not because they want to breach the law or breach the data protection security policy, but it's a part of the day-to-day work. You just have to be aware of it, and you have to train your people, to inform your people, make sure that, and it's not done with once. I mean, you really have to repeat it on a regular basis.
Yeah, I think it speaks to what Paul said, is now it's not just about saying you're compliant, it's about auditing, and it may be internally checking on what your teams are doing as well. This is an ongoing, this is something we're all going to be living with as businesses, I think. Go ahead.
Yeah, I was just thinking that the parallel with bribery and anti-bribery is very apt. One of the major cases where a UK company was found guilty of breaching the Bribery Act, the judge in his judgment said there was a fantastic anti-bribery policy here, but it was gathering dust on a shelf, and that was, quote. And so the point is that if we then look at the GDPR and the terrible example Martina's just shared with us, the defense to that is that you then can show you have processes in place. You have taken this overview of all your data flows, you've trained your staff, you're doing all the right things, so that while it is still a terrible moment when you discover this has happened, in terms of prosecution, you actually have the defense of being able to show this was one moment of human error, and we did all the following things. So at least it would reduce the fine from maybe 20 million euros to 19 million euros, so you wouldn't really need to worry.
Well, and please, we'll talk about fines shortly.
Yeah, no, and I just wanted to add to that. I think it really is about building a culture, a mindset of compliance. So whereas in the past, I think, you could maybe do a one-off training on things like, anti-bribery and corruption, etc. I think, especially with this new regulation coming into force, it's reminding your employees on a constant basis, the data that they're dealing with is very sensitive, and making sure that, that training is regular. I mean,
Right.
It sounds quite tragic, but I did share with our supplier network in a previous event that October in BGRS is called Security Awareness Month, and every single employee in the company has to do a fascinating 2-hour-long, it might be slightly shorter than that, but security training, which mandatory for everybody. But it really is to remind every single employee in the company that just doing something as innocuous as opening an email from a sender that you don't know particularly, well, you don't really recognize, and they've got a link in there, that opens our company up to massive risk.
Right. I did a de facto audit on EuRA earlier when I brought Tad a flash drive and asked if he could help me print a document. And I'd be glad to know he immediately said no and sent me away. So, right answer. And I promise we'll pass this microphone around shortly. But the last thing is the question of penalties and fines. I think there's a lot of fear about that. But Gordon, you pointed to the fact that showing that you're prepared, showing that you have the practices in place will go a long way to protecting you, I would guess. And then maybe we can talk about the insurance aspect of that afterwards, if there's something to add. Go ahead.
Yeah, and I think particularly in the context of the relocation industry, the kind of data people are using, the legitimate reasons we're using personal data for, is a million miles away from. If you look at where most fines occur just now, it's health authorities, it's police authorities losing very sensitive data, being very careless with the data. And the other big category is marketing organizations who are sending out millions of spam emails, texts, etc. These are the kinds of organizations who will be subject to large penalties. And just one thing that occurred to me when Paul had spoken this morning, when you're thinking about insurance, and certainly this would be true in Europe, and it may be different in the United States, you cannot insure against a criminal penalty. So if you are subject, if you have really done something crazy with the data and you are going to be subject to a penalty, you can't insure against that. What you can insure against, and correct me if I'm wrong, Paul, would be the damages claim. So for individuals who are affected by that breach, who may want to bring damages actions against your company, that would be covered by the insurance, but not the penalty. Yeah.
Okay.
So a lot of the people who we speak to about, are we on?
Yeah.
About data breach and cyber risk insurance, one of the first questions they ask is about penalties. And there's more than one type of penalty, and there's several jurisdictions, and there's definitions, and a lot of things apply. But in short, there's three key things to remember. There's first, you can be penalized for not being compliant when there hasn't been a data breach. So someone comes by and says that you've taken a cavalier and flagrantly laissez-faire approach to your data security, and therefore we are going to fine you. This is not insurable, and there's no trigger for coverage. That otherwise, everyone would buy cheap insurance, and it would be a get-out-of-jail card, and that would be against public policy. So that is not a fine or penalty that is covered. If you have a loss, and as we discussed earlier, you can have a loss and be very compliant. If you were compliant and you have a loss, there are fines and penalties that can ensue. And some of those are criminal, and again, it would be against the best interest of the public and counter to public policy to insure those, and various jurisdictions have different approaches to what fines can and cannot be insured. If there are exemplary damages that are handed out to make an example of you for the better of society, but that don't really reflect the degree to which you were more guilty than the average person, then these types of things can typically be insured. And again, you need to look carefully at your jurisdiction. One of the better ways to approach this is to do it as an association, where the association would be situs in a place where this was most favorable, and then you could benefit through the association in the domicile where they had a favorable approach to, and this is a practice that is not a cheeky workaround. It's actually an established and vetted practice that is not typically frowned upon by local authorities.
Very good. All right. So there we have it. That's it for now for my questions in the expert panel. Anybody have a question? I've got a microphone I'd be happy to share. There we go. We'll start here and then back there. Yes, it should be on.
Thank you. Yeah, okay. So my name is Pauline from Box Global Expat Solutions. Basically, our clients are clients who outsource their global mobility department to us for all aspects, so tax, immigration, assignment, coordination, global mobility advice. My roles, I'm also on the GDPR team in our company. Until this morning, I thought we were data controllers. if I understand correctly, we're actually data processors. So we should have a processor to processor agreement in place, where we have a controller to processor agreement in place. So I was wondering, do we have to reverse everything? Because we already sent out all our processing agreement last week.
Okay.
My top of the head advice on this would be not to immediately reverse everything, because at the very least, the GDPR, the wording of it around controller and processor is broad enough to encompass what you're doing and to describe that as a controller relationship. The key thing is, what does your contract say at the moment with your corporate clients who are outsourcing to you? So if it says, we are outsourcing to you on the basis that you will gather in all this data and you will be responsible for that data, then I don't think you need to change anything. You can, at the very least, wait until things have settled down a little bit, and there's lots of learned articles from lawyers and IT experts saying, you know, in this particular situation, we recommend A or B. But it sounds to me, the way you've described it, I think you can be a controller, and I certainly wouldn't put everything into reverse. But Ronald will now say the opposite. So.
Yeah, you did. Yeah. Yeah.
Okay, I've been set up, yeah.
No, but you know, I think this comes back to the whole question of intent and are you doing your best to comply at some point, right?
Yeah.
They made the effort. They made a genuine effort. So.
Yeah, and the clarity too, so that as long as it's clear between your client and your organization who the controller is,
Yeah.
even if you could argue that was a technically wrong interpretation,
Yeah.
The individual whose privacy we're all trying to protect here knows that you are the controller, it says so in the documentation, so there's complete clarity around if something goes wrong, you know, who do they complain to, you know, what are the steps they take. So again, I would be relaxed, even, you know, if we're taking slightly different interpretations of the legislation here, that's fine. It's the clarity in your contract with your client that, and everything that flows from that.
Okay, great, thank you. And then about the processing agreement, there is a standard clause when you talk about personal data or sensitive data, things like that. It also says we have to ask our suppliers who their subcontractors are. But that's really difficult because a DSP has many consultants, has many a lot of changes in their consultants and things like that. So it's almost not possible to determine that. How do you go about with that?
Yeah, my practical answer is you describe all the categories of subcontractors you use.
Oh, okay.
So in a perfect world, yeah, you would name them all and they'd be there in the contract. But if you can say, well, we can't name all these individuals because there are so many, we can describe them in terms of data will be shared with the following categories of subcontractor and list them, would be my answer. Is that?
Well, if she has the agreement with the DSP, is it then the responsibility of the DSP to have it in place with their people? Sorry. So if Pauline contracts with the DSP, she has the data processing agreement in place. Is it then the responsibility of the DSP for the downward agreement?
Yeah.
She can't go that far because it doesn't stop with the DSP. With the consultant either, right? It then goes on to the real estate agent and the school admissions board where the consultant is helping with the enrollment procedures.
Yeah, but we can determine the categories. So
Right. But
the answer is, for me, it's a good answer. I can work with it.
But I want to hear from the attorney
Yeah.
if the buck stops with your partner.
Into the stage, right?
You'll be getting your invoice.
Yeah.
This goes all the way back to the controller and the consent that's being obtained about my data being shared. And it's the controller who's responsible for saying, this is how we will handle your data, these are the purposes, and these are the categories of people with whom your data will be shared. So that in turn, then leads to a sub-processing agreement when the DSP, as Ronald points out, will then have in place agreements with these individual suppliers. But I would still go back to that initial controller documentation that you issue to the individual should state the categories as well, although it's covered further down the chain too. But it's that privacy notice, consent form, whatever form of documentation it takes, should be as clear as possible about who data is then going to be shared with.
Great.
Just to the extent that this is not new to us, because we've been collecting information and sharing it with third parties forever, and we've been collecting it in forms and having to meet a higher standard than is in GDPR. Whenever you complete a healthcare application form, at the bottom it says, I consent that you use, and we will be sharing it with third-party administrators and underwriters and various third parties, and that has been what we've used as a guiding principle. Now, do we go share it with auto mechanics? No, because that would not be a normal thing to do. But we even have a bit of the blurb and says, and any other organization or entity that would be normal to the practice. So
that's what we put in our consent with the expats, for example.
Right.
Yeah, I think that this cascading, doing it over and over and over again, is probably a safeguard.
Safeguard, right.
Yeah.
But sounds like a best practice.
Yeah, it's got us through multiple audits.
Yeah. Because, my last question. So about the consent form for the expats, can an expat give consent for spouse and family, or do they have to sign a separate? Okay, that's a clear answer.
Yeah. Okay.
That's clear.
The way to deal with this, I would suggest, because this has come up as a question a few times in real practical situations, because you're looking at a form that you plan to send out, and the spouse may be in the other side of the world, and you want to get things moving as quickly as possible. So I would build into the form the name of the assignee, a second signature for the assignee to sign on behalf of dependents, and then to be aligned for the spouse to sign as well. But if the spouse cannot sign, I would be sending that by email, because you don't need a signature, you need affirmative consent. So if you send that as an email and ask them to confirm by email back to you that they've read the form and they're happy with the content, that is sufficient consent. Now, administratively, I know that people will be saying, well, how do we then capture all this? We want everything on one form or two forms, and we want a signature. But that's your own internal rules, But from a legal point of view, as long as it's affirmative, somebody has read a clear statement of what's going to happen to their data, and they've confirmed they're happy, it doesn't actually require ink at the bottom of the page.
This is for Manpreet. The logical extension of downward flowing contracts, compliance contracts, I wonder where it ends. It was mentioned earlier that terms of agreement are clicked and okayed all the time without reading. It is reasonable to conclude that there are going to be vendors that do not have a thorough reading or a legal reading of these contracts and are signing them and are sending them back. Do we go to a place where there are penetration tests? Do we go to a place where there is a certain budget for your security that wasn't in place before?
Yeah, absolutely. So I mentioned earlier in the session earlier this morning that, as an organisation, we've made the choice, even though we don't have to appoint a DPO, but also created an additional position in auditing to audit our supply chain. So exactly for that reason, in the session that I did for our supply network in Singapore, I was very clear on the fact that I really needed them, you know, if they'd received our amendment to the vendor agreement that we have in place to cover us under GDPR, I needed those back by a certain date, and that if we didn't receive them, then, you know, we just would not be able to continue to do business with them. Now, immediately after that session, we got a great influx of signed amendments, which did obviously make me wonder about whether, you know, they had been thoroughly understood and, you know, the necessary procedures put into place to ensure that that downward obligation is being fully fulfilled. So yes, we as an organisation will be getting out there the same way as our clients do to us to actually audit to what we have said we are doing.
Hi, this is Priyam from Helma. My question is in regards to the relationship between DSPs and consultants. For consultants who may have the email ID of the DSP's company, to what level should the control extend to that for that consultant? Should the DSP control and provide them with a corporate laptop, a corporate phone, determine the antivirus, or should the DSP simply say that in the GDPR environment you use your personal email ID, you sign a contract, and then the DSP sleeps well at night?
Okay. Yeah, that is a really interesting question. So on the practice side, my recommendation is put down a framework. I'm working as a freelancer for a very big corporation. So, and I get really strict framework. What I have to do, I'm using my own laptop, but of course I'm in the intranet of this big corporation and sending, you know, data back and forth. But I have a really strict regulation about my firewall system that I have to update, which one I have to use, and so on and so on. It's more than a policy. It's the procedure I have to follow. And yes, and they are checking it from time to time, you know. And they are checking it, sometimes they can do it like an online audit, so they really check how up to date my firewall, my data security system is, and so on. That would be really my recommendation. You have to train them or inform them, whatever is possible. As a freelancer, my understanding is they're not employed, they are on a freelance basis working for you. So train them, put down a framework, rules, procedures. What are your expectations in that kind of working environment? And yeah, that's it.
And just from a risk management perspective, if you were to want to have a cyber risk and data breach insurance, someone who is working as a freelancer or independent satellite of your company can introduce a lot of risk to your operations by how they operate. So it's in your best interest for two reasons: to sort of embrace them, bring them inside your operations and systems and firewalls and intranet, and list them as a de facto employee for coverage. If you want to perpetuate the relationship where you have them as an independent, it was probably a good practice to ask that they show you evidence of their own insurance that will be triggered first in the event that there's a data breach that emanates from their home or from their laptop that protects you as well.
This doesn't sound very legalistic, but I think there also has to be a layer of common sense here. Otherwise, we're just adding a substantial layer of cost to the way we do business. And that would concern me, because this is about privacy. It's an important principle. It's not about making businesses less efficient. And I'm sure that many DSPs will have consultants they use just once a month, and trying to build an administration around them, bring them into the intranet, etc. There may be very good reasons for doing that, but if in practice that's very difficult, then I would go back to first principles. You know, making it clear what data protection is necessary, what you require of these consultants. But let's not bring a huge extra layer of bureaucracy into the way that you work day to day, because ultimately it just is going to add to cost. So a little bit of common sense, I suggest, is required here too.
Yeah, just to add one more comment on that and make a sales pitch for cloud solutions. I think tracking of where all the information is in this regard one of the biggest challenges for us, right? And so that gets indeed worse when you have independent contractors where you don't fully control the devices that they use and maybe even the software. So I would, this was step one for anybody that went through this process, is do your data mapping, understand where your data is, and frankly, as much as you can, try to get it in the cloud and then figure out a way indeed how to protect it, because that will go a long way to simplifying things. I mean, the common sense aside and bureaucracy aside, simplify your data flow and you will simplify your life.
I'd like to add something. We are all talking about cloud and software systems, and I'm absolute supporter of such stuff, but I know a lot of companies, relocation companies, who are still working with paper in their hands because it's they're still going to appointments with transferees or to show them houses or have experience or whatever. They have paper in their hands. And please be aware, we are talking about personal data, we are talking about paper as well. So it's not only the data we have on the sticks, on the laptops, on the iPhones, and on the computers in the office. We are talking about print out personal data as well. And then I'm coming back to the people who not only have work in the office, they have home offices, they work there, and yeah, make them aware that everything that is print out would be a data breach. To put the papers and put it in the house garbage, or give to the kids to turn it around and scribble on it. That is that is life, okay? And that happens a lot. So just to have to make them aware that that would be breaching the GDPR.
And on that point, we are in the marketplace selling cyber liability and data breach insurance all over the world. And we pay claims all the time, and we investigate claims all the time, and everyone thinks that, you know, I'm not going to be the target of a bandit group of mercenaries working in a basement somewhere, targeting me for terrorist purposes. Many of the claims that we encounter talk about people leaving a book of business on the bus, or leaving it in a hotel, or a laptop in a taxi cab, and these types of things. This is in very much fact, in every respect, as equal a threat as our hostile cyber attacks and ransomware and these sorts of things.
Good point. Any other questions for the group? Really? There we are.
Yeah, I wanted to ask from an immigration point of view. We work with RMCs and immigration law firms predominantly. We've always seen ourselves as a sub-processor, being a DSP. Now obviously there is certain information that we're going to need to get. Most times that goes back through the RMC or the immigration firm that we're working with, and they will get it from the clients. Sometimes they put us in direct contact with that assignee. It all just depends on the case, because the assignee might be in country, it's easier to just speak to them. Are we going to now have to sign controller agreements as well, just to get that information? How do we work that?
Okay, so I'm just going to share the experience that we have at BGRS. So we would consider the corporate client to be the controller, us as the RMC, the sub-processor, and then any immigration provider that we work with and therefore outsource the immigration process to really, you know, be covered to be covered to an extent by the consent that has been put into place by the corporate client. However, because immigration providers do also collect data that falls into that special category of data, what we have found that many of our partners have actually sought to ensure that they're 100% covered, to request a secondary consent directly of the assignee or the transferee, to ensure that they are fully aware of the fact that things like religion, sexual orientation, biometric data, etc., you know, that you obviously will be requesting it and then you will be holding it, and it's all for the purposes of you managing their immigration process.
Anybody else?
Hi, this is Maddalena from Professional Relay in Italy. I think it's clear that we have to erase documents once they are no longer needed. What is not fully clear to me is what to do with emails. Because I saw, or I was told, that even emails should be deleted, but emails may contain important information that might become useful even after years for any reason. I don't know. So I wanted to understand better what does that mean.
Yeah, so you're really talking about having a deletion policy, and that will be for different categories of work that you do. So for example, if you do immigration work, that may require documents, including emails, being retained for a far longer period than a one-off service like an orientation visit that has a beginning and an ending, and you possibly your deletion policy would say within 1 year of that would be deleted. So you really have to go through each category of service that you provide, and in doing that, you're really building in emails as just part of the personal data relating to that individual. Because again, you come back to the definition: can an individual, a living individual, be identified from that personal data? And so presumably they can. And you know, if you had a case management system, it would contain all the data and it would have all the emails attached to it. And once you delete that file, that's everything gone, and you delete the backup file as well. But that may be 10 years down the road, 7 years down the road, depending on your business assessment of what is reasonable. So yeah, I don't see a way you could separate out emails from other personal data. Yeah.
No, I agree. The data is data. It might sit as a piece of text in an email. It might be a document. It all applies to it. That goes back to what we talked about earlier in the previous session around the data retention policy. Where things get a little complicated, unfortunately, is the GDPR essentially says, look, keep the data for only as reasonably necessary to, in this case, deliver the relocation services. But then the local law, even within some of the EU member states, says, well, if you did an immigration application, you have to maintain this data for at least 7 years because the Italian authorities might come and do an audit on you. So that's why the classification of the data is relevant, and that means some data you have to, can you destroy earlier than otherwise. This gets more complex when you then, for example, do the visa renewal 2 years later, because now you basically move that timeline out again. So I'm going to say it again, try to figure out how you can all put this in a cloud-based solution of some kind, because it will be practically impossible to keep track of this otherwise, and to go scrub the data, right? And how we deal with that, we honestly don't know yet, because somebody's going to test the system and say, I want you to delete my data, and then we have to respond to it. And it starts with the controller then, by the way, who goes back out to all the processors to share the news that this was now what's required.
The Financial Services Authority in the UK application form and guidance on financial services is 5 feet tall. It's very, very hard to navigate. And from time to time you have to call and ask a question. What did you mean by that? And the person who wrote the question doesn't work there anymore. But ironically, the question with respect to how long you keep data, the answer is very clear. It says you need to keep data as long as you need to keep data for, which I thought was well worth the phone call. But because we work in liability, and in certain instances we can have a claim that might require us to write a check for $100 million for something that happened a long time ago, we really need to keep things forever. And then you have the question of import and materiality and relevance. You think, okay, well, this is just wishing me, a happy holiday break. I don't need to keep this one. But then you have one missing email. And people will say, well, why is that email missing? Because you've probably scrubbed something that you're trying to hide, so you don't have to pay $1 million. That's not the case. So what we do is we keep everything forever. Even the holiday greetings.
I was just going to add on the end of that. So obviously under GDPR, it's keeping the information or the data for as long as is required and reasonable for the delivery of the service. And then in different jurisdictions, it's changes, as Gordon said earlier. But I think also you need to look at what you have agreed with your own clients, because I know that our clients request that we maintain their data for a certain period of time so that they can, potentially audit. So that length of time, I mean, it's like identifying, well, how long's a piece of string, really? It will be a different number for every different business.
I'm just looking here at the Law Society guidance, and it tells me, for example, if I act in a divorce, I have to keep the papers for 5 years afterwards. In a criminal case, if the person ends up with life imprisonment, I have to keep the file indefinitely. And so it goes through every single category of legal service, and most are between 5 and 10 years.
Anybody else? Yes. I need to stand next to that row, I think.
Martina Meinhold from Management Mobility Consulting France. I have a question related also to all these other categories of people, because we're always talking about assignees, our own employees. But for a home search, for example, we are not only in contact with the assignee, but also with the landlord, for example, the housekeeping personnel, the nanny, any kind of insurance broker. Do we have to ask permission from all these people to keep their contact details? Another question, we get a lot of visit cards here on the conference. Are we allowed to keep them? How much time? Do we need consent?
I wrote an article about business cards. Yeah, you didn't read it. The rule on business cards, if you hand out a business card, there's a reasonable expectation that you will be put on that person's Christmas card database or newsletter database. But when they come back to you and you receive that newsletter, of course they have to put on an unsubscribe facility, so that's where the legal obligation then goes. I think you have to really go through your different categories, but bear in mind we separate out personal data content. So if I start sending an email to an individual, I need their consent in advance to do that, to put them into my database. If it's a business contact, then it's the unsubscribe facility that matters. So if you've got a landlord contact and it's going through their business address and you're regularly dealing with them and you decide to send them a newsletter, your problem would be if you don't have an unsubscribe facility. So that's the kind of distinction. It's actually under a separate e-privacy regulation that actually deals with emails and how they have to be dealt with.
But did we answer your earlier part about the landlords and the other?
Yeah, so there's a legitimate business purpose in you keeping that data. Yeah, that's not a problem. If you decided you wanted to build a database of all the landlords in Paris, that would be different. But you've got a legitimate interest in doing that. It's part of the service. So I don't see a problem there. Again, instinct would normally tell you if there's a problem.
Consent is not, I think, to back up your point, consent is not the only way to obtain legal basis for maintaining the information. So that's, I think, what you're referring to here. It sounds simple to have everybody sign a document that they're consenting, but again, that's not the only requirement. So keep that in mind, because you're covered there, because you will have a copy of the lease, right, of that landlord. Well, you have a completely legal justification for having that, because they signed the lease with you or on behalf of your assignee.
We have a newsletter that we send out with an unsubscribe facility. And my question is, do we have to inquire about this new regulation. Do we have to make out a letter saying, would you consent? Would you give the consent for us to send out again, or not? Or did you understand my question?
Yeah, yes, I do. And I have noticed a lot of companies are doing exactly that. They're going out. Now, as I say, if it were personal email addresses, definitely. There's no question of it at all. But if you're sending these out to business email addresses, my understanding of the e-directive on this is that it's the unsubscribe facility that matters. So you may want to, as a matter of good practice, be going out to your complete database and tidying the whole thing up. And I think that's what a lot of people are doing. But technically, if you sent out your next newsletter on the 1st of June, I wouldn't be too concerned. As long as it's all business email addresses, it's going to. But as I say, maybe use this as an opportunity in terms of what is best practice. I think a lot of companies are tidying up their databases for business emails too.
Very good. So I think we have time for one more question before we wrap up. Sorry.
I would like to stay with the landlords. We have the consent from our client that we are allowed to send an application for an apartment to a landlord. Do I have a responsibility what the landlord does with the data? That's my first question. And then also you said before that we get some more information about fines.
I think we spoke to fines, so we'll bring that up. Yeah.
Right. So you're sending data with the employee's consent to a letting agency or a landlord. They're not part of your network. So you're just acting as agent when you do that. So if that landlord lost the data or did something stupid with it, no, I would not see that as your responsibility, as opposed to a subcontractor. If you had a network of agents acting on your behalf, you would need contracts in place with them, and you would have a responsibility. And the example I would use that's more extreme would be you send into a government department for immigration purposes personal data, again with the employee's consent. If they lose that data or misuse that data, nobody would suggest for a moment that you could be responsible for the negligence in that government department. So that's a parallel I'm seeing, but I appreciate there are gray areas around this. Is somebody part of my network, or is it an independent contractor? I don't know if that's something that anyone in the panel has had to address. But that would be the distinction I would make. Is it your subcontractor, or is it somebody else in the supply chain who's completely independent?
Yeah, probably. To add to that point, it's because the person who owns the data has the right, as you probably know by now, to withdraw all and to ask you where the data, the personal data, are. So what you have to know on the personal side is what kind of data you forwarded to which company, to which landlord, and so on. But that is really on a personal basis. So you have to keep track on what kind of data do you forward to what kind of different companies and individuals. And I think that is probably more important in the bigger question, because that might happen in the future. I don't know what your experience is, but I think just to try, if it is working, there are people out there in our societies that like to try if a company is able to track the personal data of themselves, and so they will ask you to give advice and provide information where all the personal data are.
Yeah, that is a very good point. So for different kinds of suppliers, if you're obtaining consent from an individual to share data with, say, it could be anything from immigration authority, a landlord, a broadband provider, you should keep a note, and in fact your consent should be specific to that, and you should say, to set up your broadband, I need to provide the following personal data to the broadband company, and so the person knows exactly what data is being shared, which of course is quite different from what would be shared with an immigration department.
And I know I said we'd wrap it up, but I think this is important, so please, Asa.
I don't know. I was just thinking of the people who will contact us saying, I want all the information about me deleted. Yes. What do we do with that? Because I would go back to the RMC or to the company who had ordered the service to say that this has been requested. How would you like us to proceed?
Yeah, I mean, the answer to somebody who wants their all their data deleted from your system, it really depends on where you are in that service. And the point's already been made that you may not even have to rely on consent. You know, if you've signed a contract with somebody, you're delivering a service to them, you're entitled to complete that service and receive the payment you're entitled to contractually. And so they can't say that, oh, but you can no longer process my data, because that's a contractual obligation that you have undertaken. Whereas if it's related to something where somebody has specifically provided consent, such as to share data with a third party, if you've not shared that data yet, then of course you should comply with that. But picking up your point about the controller, it is the controller who has the ultimate responsibility here. So any requests for that, and it would be in your contract with, if you are a DSP, your contract with the RMC, and forgive me if I'm wrong here, will almost certainly say, in the event of a complaint, in the event of a request for deletion of data, and it would go through a list, you must notify the data controller or the processor above you in the chain, whatever, however it's set out. So, you know, as these contracts are updated, and I know from speaking to some DSPs, they're still waiting for, not of course from anyone in this panel, but there are some of the RMCs who've been a little bit slower in providing the contract amendments. And so I think some DSPs still are wondering, you know, what are these changes going to look like? What are the details of them? But clearly these will all happen in the next 28 days and 10 hours.
So yeah, I just wanted to add off the back of that from the RMC perspective. Yeah, if an employee approached you directly, as the DSP has, you were the last person they were in contact with and they've forgotten everybody else they've had any dealings with, then our expectation would definitely be that you would share that with us. We would in turn share it with our corporate client as the controller, and then on the basis of the request that has been made, we would decide whether it is a valid request for deletion of all data or not, and then, you know, may well then flow back down to you to actually delete that data, but we'd also need to delete data from our systems and potentially also the controller.
Terrific. All right. Thank you. And I do want to thank, first of all of you for showing up again after lunch. It's a difficult session sometimes, but most of you were able to stay awake, and we do appreciate that. So thank you for attendance, and please, a big round of applause for our panel. I think they did a terrific job.